Good afternoon. I am Professor Trina Jones, and on behalf of the Center on Law, Race, and Policy, I would like to welcome you to today's discussion of AI, intellectual property, and marginalized groups. Thank you all for being here. We would like to acknowledge a special guest, Mr. Charles Smith, who received his LLM from Duke and in 1973 became one of the first Black patent attorneys in the United States. And he was acknowledged for his substantial contributions to the legal profession by the North Carolina Bar Association as a legal legend in 2025. Would you please stand up, Mr. Smith, so we can acknowledge you? We would also like to acknowledge the other distinguished professionals who will be continuing this conversation with us later this afternoon. They are April Dawson, who is a professor and associate dean of technology and innovation at NCCU School of Law, Angela Foster of the law firm of Angela Foster, Philip Hampton, a senior partner with Polsinelli Law Firm, Kirby Lee, the associate general counsel at Ecolab, and Todd Baker, a partner at Kirkland and Ellis. Thank you all for joining us today for a series of This event is in remembrance of our alum, the Honorable James D. Smith. Judge Smith served as the Chief Administrative Patent Judge at the U.S. Patent and Trademark Office and was responsible for establishing the Patent Trial and Appeal Board, which I think is known as PTAB. During his illustrious career, Judge Smith also held prominent positions in academia and led in-house intellectual property teams for several multinational corporations. The Center on Law, Race, and Policy benefited from his insights and his time during his law, and we are extremely grateful to have been associated with him. We also would like to thank his family members who are joining us today by live stream. I'm pleased to invite to the podium Professor Arti for introductory remarks. Professor Rai is the Elvin Latty Distinguished Professor of Law and Faculty Director of the Center for Innovation Policy at Duke Law. She's an internationally recognized expert in intellectual property law, innovation policy, administrative law, and health law. Throughout her career, Professor Rai has served as a trusted advisor for numerous governmental entities. From 2009 until 2010, she headed the Office of Policy and International Affairs at the USPTO, where I believe she had the honor of engaging with Judge Smith. Professor Rai.
Thank you so much, Trina, for that very generous introduction. I would like to say a few words in memory of my friend, the late Judge James Donald Smith. By my count, Chief Judge Smith lived at least 3 different lives. He was a prominent leader in the private sector, as Trina has already noted, first as a distinguished appellate patent lawyer at several law firms, and then as first Chief Intellectual Property Counsel at Lexmark, then Global Director of Licensing at Nokia, and then Associate General Counsel and Chief IP Counsel at Baxter International. Just that record would have been more than enough for most of us. In fact, more than many of us can say that we have accomplished. But Judge Smith was just warming up for his second act. He then served, as Trina has mentioned, with tremendous distinction as a public servant. Early in 2011, he was appointed by the Secretary of Commerce as the Chief Administrative Patent Judge of something that was then known as the Board of Patent Appeals and Interferences. Very soon thereafter, however, he would become the very first ever Chief Administrative Patent Judge of the newly minted Patent Trial and Appeals Board. The PTAB, as some of you may know, represented the biggest change to patent law in over 50 years. So he wasn't simply filling big shoes, he was creating those big shoes. Congress created the PTAB specifically to serve as a robust, technically sophisticated alternative to expensive and sometimes inefficient, quite frankly, litigation in Article III courts. So those were extremely big shoes to create and fill. And I think in large part, the PTAB has succeeded in achieving its goals, Congress's goals, because of the late Judge Smith. Throughout that record of public and private service, and now I'm turning to his third life, Judge Smith retained close ties with legal academia. He served as assistant dean at Emory University Law School, and later as a professor at multiple institutions, including the University of Minnesota. And of course, we at Duke Law are particularly grateful and proud of his long-term service as a member of the Duke Law Board of Visitors. In fact, that was the context in which I first met Judge Smith. By then, I had actually left the PTO. I'd done my job advocating for the creation of the PTAB, and his tenure followed closely thereafter. When we met here, I believe in this room, actually, his reputation had, of course, preceded him, so I was a little bit intimidated. By reputation, he was working 80 to 100 hours a week at that point, establishing the PTAB. And yet, somehow, between doing all that intricate rulemaking to set up the PTAB, hiring hundreds of expert judges, he made time to come down here to Duke. And I don't know how he did it, quite frankly. I know our former dean, David Levy, particularly valued Judge Smith's keen insights about private practice of law, public service, legal education, and the wild and woolly world of DC policy. And I think it's fair to say, again, with respect to the PTAB, that without Judge Smith's rare combination of technical expertise, he trained as an electrical engineer prior to going to law school, legal acumen, of course, required at Duke Law School, and institutional leadership, the PTAB wouldn't have emerged as the well-respected institution I believe it has become. As the PTAB established itself, I was writing a lot about the administrative law that governed this new institution. And at the time, the Supreme Court's administrative case law suggested that it might be, the PTAB might be the first institution within the USPTO to routinely get so-called Chevron deference. Chevron's now gone, of course, but at the time, that's what the Supreme Court was, the case law strongly suggested. So Judge Smith was also a trusted advisor to a Center for Innovation Policy that I helped co-direct, and we invited him for a conference on the PTAB as he was serving as Chief Administrative Patent Judge. Several of us were very excited about the PTAB's potential newfound power and potential ability to receive Chevron deference. I thought it was very interesting that Judge Smith urged caution. He wanted to be sure that both as a legal matter and as a matter of institutional competence, the PTAB would deserve that deference. And I thought that was really striking. Most people seek to grab power. He did not. He sought to establish the foundations that would merit deference. I think in that regard, he stands as an example to all of us today. After returning to the private sector, having established the PTAB, Judge Smith served as Chief IP Counsel at Ecolab. And in that capacity, he oversaw global patent, trademark, and copyright operations. As many of you know, Ecolab is a global leader in water conservation and energy efficiency, using law and innovation to promote those social goals seems to me to have been the perfect role for Judge Smith. Across his varied positions, Judge Smith advanced a vision of intellectual property as both a technical discipline, which it is, but also a public regarding enterprise. And his legacy in those respects endures in all of us. I hope certainly in me. In closing, I should also mention that Judge Smith was relentlessly curious. As I mentioned, he trained as an electrical engineer. And for that reason, I can't imagine anyone who would have been more excited for today's panel about AI. Having the Center for Race, Law, and Policy host a conference about AI and all of the very diverse social issues raised by AI seems to me the perfect tribute to Judge Smith. So with that, I will turn it over to the panel. Thank you.
Thank you. I am now pleased to introduce our distinguished panel, and they are all truly distinguished individuals, but I'm going to be brief. So you can read more about each of them by checking out their bios online. Brent Clinkscale, the moderator for today's panel, is a double Dookie, having received his BS and JD degrees from Duke University and Duke Law, where, among other things, I believe I was told you were the quarterback on the football team.
At least one of them.
And the president of the DBA. Mr. Clinkscale is an independent arbitrator, mediator, and litigation consultant, and managing member of the Clinkscale Global Alternative Dispute Resolution Enterprise. He serves on the arbitration panels for the American Arbitration Association and the International Center for Dispute Resolution. He is also a member of the CLRP, the Center on Law, Race, and Policy Advisory Board, and the driving force, truly the driving force behind today's event. So thank you. Joining him on the panel are Olufunmilayo, who is a professor of law at George Mason University, where she teaches and writes in the area of technology, creative industries, business law, entrepreneurship, comparative law, and Africana studies. She is the author of the award-winning book, Disrupting Africa, Technology, Law, and Development, which examines the legal and historical context in which new technologies are introduced and used on the African continent today. And our careers have overlapped for some time, so it's wonderful to have you here at Duke Law. The Honorable Scott Boalick is the former chief judge for the Patent Trial and Appeal Board, where he served for over 18 years in various judicial capacities before departing in 2025. Before joining the USPTO, Judge Boalick was a patent attorney with the Department of the Navy, where at the beginning of his career, he also served as an officer. Joseph Drayton is a partner in the litigation department at Proskauer. He is also the co-head of the firm's patent law practice. His practice spans all areas of IP law, from patent, trade secrets, copyright, trademark, trade dress, and false advertising, and he operates both domestically and internationally. He has over 2 decades of experience representing some of the nation's most prominent companies in high-stakes IP and complex commercial litigation. And he was the 76th president of the National Bar Association. And last but not least, Detavio Samuels is one of corporate America's youngest and most accomplished senior executives. He wears multiple hats as the CEO of REVOLT, the nation's leading creator and distributor of hip-hop and Black cultural content, and CEO of its parent company, Offscript Worldwide. He is also a graduate of Duke University and has been quoted as saying, and correct me if I'm wrong, that his freshman year was one of the most important years of his life, in part because he pledged Kappa Alpha Psi, in his words, will go down in history as one of the best decisions he ever made in life. End quote. I mention that because my understanding is there are quite a few Kappas in the room. Without further ado, let me turn this over to Brent.
Let me say no lies told.
So wow, this is a great day, and this is a great crowd. So next time we will have lunch and dinner. And you on me. You've heard a number of names in here. I just, as a fellow Dookie, all of these individuals that you have heard are leaders in their firms, in their professions. So if you interview at one of those firms or you have an opportunity to come across them, just tell them that you were here today, and you will get the job. This is an incredible panel. Let's take advantage of today. Let's don't waste this opportunity. They come from different places on this particular subject, but they are very connected. And I dare say, depend on each other's profession. Detavio is in the business of creation. Joe is in the protection of that creation. The judge is in the management of that creation. And Fumi is in the understanding of the presence and the future of that creation. We will explore this in the context of AI and marginalized groups and through the perspectives of this panel. What's the definition of marginalized groups? Lack of access, lack of economic viability, lack of knowledge, lack of an effective platform. Of course, the panel can define it as they wish. There's a great book on, I think, called Simple Justice, which is about the courageous plaintiffs in the Brown case. It's not about the lawyers, and it's not about the judges, but the courageous plaintiffs, because they're the ones who had to bear the brunt of the vengeance. So with that, let's start with those who have the courage to create. Detavio, what is this creation that you have, REVOLT and Offscript?
Sure. First and foremost, thank you for having me here. It's an honor to be back in Duke and to be here with my brothers in Kappa Alpha Psi, including my chapter brother. Quick shout out to my beautiful wife, Drayton, over there, and my assistant, who will be in these seats soon. Duke Law is one of her top law choices. Okay, from my side, so for those of you guys who don't know, I'll start with REVOLT. REVOLT was founded in 2010. I used to be able to say by the legendary, iconic Sean Diddy Combs, but we've had a long journey on that one. So you can't say that anymore, but the headline is we were known for being Sean Combs' media company. It originally started out as like a recreation of MTV. MTV had walked away from music and music videos and music television. And he had a vision to reinvent that, reimagine it for, at the time, it was the millennial generation. So that's how REVOLT got its start. I joined the company in 2020. Basically, I've been the CEO since the day I started. We really were focused on turning the business into being a media company that would be powered by creators. Since 2015-ish, I've always believed that creator was the future of media, that influencers were the future of media. And so at the time, we were getting an early start with basically 100% of our programming coming from creators and influencers. On that journey, we've had some of the top talk shows, podcasts, in the culture, cool culture, hip-hop culture, over the last decade. If you're familiar with podcasts like Drink Champs, I don't know if you guys know Noriega. Again, that's like early 2000s. if you know Noriega, the hip hop star. Carisha Please, if any of you guys were into the City Girl life or any of that, was one of our hit shows. So that's the work and the content that we've been in over the last half decade since I've been there. Last year, we announced Offscript, which is our new parent brand. The role in Offscript was, if REVOLT is a media company that's powered by creators, the media industry is in turmoil. It's very hard to find players who are winning. My belief is you can't find a radio, print, digital, traditional, cable, television company that's winning today. The only people who are winning are like the media tech giants. So you're a big streamer, Netflix, Disney Plus, Hulu. You are social, TikTok, Meta, Instagram. You are creator. Creators are getting, today I always say creator media is bigger than traditional media, more important than traditional media. So streamers, social, creators, and sports. For advertisers, live is a big thing. Basically, all viewership has shifted to on demand. So those people who can garner a live audience, a bunch of eyeballs at the same time, and that really has turned out to be mostly only sports programming, right? So those four things completely winning in the media space. Anything else is suffering. It's probably 6 companies eating 80% of the media advertising dollars. Those names I just named, Disney, Netflix, etc., eating the bulk of it, and then every other media company that you know is competing for the last 10 to 15%. So saying that was the path, the decision has been to shift or pivot from being anchored in being a media company into being anchored into being a creator company. And so the way we would say it is, if REVOLT is a media company powered by creators, also is a creator company with a world-class media ecosystem. We find ourselves to be different from everyone else, working with creators, talent agencies, influencer agencies. Those people we would argue are all transactional. They exist to get you a deal, and then they kind of move out of the way. They also don't have what we have. We have green light power. If you're in Hollywood or the business, green light power is like the most important power you can have. Those are the people who get to say, yes, this show gets made, no, the show doesn't get made. So if you're a talent agency, you don't get to pick the shows. You're packaging them up, and then you're trying to sell them to Netflix. Well, because we have our own distribution across cable, TV, YouTube, digital, social, any creator who we want, we can partner with them, greenlight their show, and make it happen, right? So we would say that Offscript, it'll be the last piece that I'll say here, we would say that Offscript is the only vertically integrated or full stack creator company. We have our own distribution, so we can greenlight shows, make shows, distribute shows. We have a studio facility in Atlanta, so creators can come in there and play. We just inked, for me, what is a landmark deal in my career. We just announced last week with Kenya Barris. If you guys are familiar with him, he's one of the co-creators of America's Next Top Model. One of his biggest shows was Blackish, Mixish, Grownish. Big movie on Netflix was You People. Anyway, so we just inked a deal with him to create a creator lab or creator studio so we can sell content to the Netflix, to the Disneys, those premium folks. So whether a creator wants to do premium content, linear content, digital content, whether they need scenes to record, if they want to do audio, podcasts, we have a music distribution company. So we have artists that are with us. So anyways, we are full stack. One creator can come. They have one home to execute all of their dreams and aspirations. The people that we focus on are what we consider, we say we partner with creators who move culture. It has a high degree of focus on people who come from marginalized groups, Black and brown creators, because those tend to be the drivers of global culture. Those people tend to be the drivers of U.S. culture. So that's the focus for Offscript and REVOLT.
Well, how does AI fit into all that, and what's your opinion of it? Is it a threat, or is it a game changer?
It's all of the above, but my energy focuses on and is excited about AI as a game changer. Within the company, I've definitely said to my exec team in jokes, but not really jokes, I want to fire everyone in the company who's not using AI. I believe that right now, I am the most dangerous I've ever been in my professional career because of AI. If you study it, you'll see people talk about like we are entering into the era where you will see more single employee billion-dollar companies than could have ever existed, because now you have a single person and 1 million robots that can go do whatever you want to do, right? So I am definitely in the camp of the AI wave is here. It's not going anywhere. I don't believe that a bunch of jobs are going to be wiped out by AI. I believe that the people who know how to use AI will wipe out the jobs of the people who don't. And so I'm very much on AI as like a game changer. Some of the places that we as a company have been exploring and dealing with AI, it's everywhere right now. So it's we see AI show up in contracts, mostly not on our side. Again, we're dealing with creators. Creators don't have infrastructure. They often don't have the budgets to hire the high degree lawyers that you all will be when you graduate. And so what do? We send them contracts, and then they're dropping it over into AI, right? And then coming back to us, trying to dispute our lawyers based on whatever AI told them. We see it that show up in that way a lot. We tried AI a lot on like the editorial side, like the tech side. So can AI, instead of hiring thousands of people to write articles, can you use AI to do that? That one didn't go so well for us. But what we did find out is that AI was really good at copy editing. So now we still have people writing the articles, but then AI can come in, copy edit, clean it up, and that saves time and money. Some of the places where I'm most excited about seeing it for ourselves and in the market, the first one is I'll talk about social. So fundamental belief, I don't care if you're TV, radio, digital streaming, whatever. In this world, if it didn't happen on social, it didn't happen. The job is to get your content discovered. If your content can't get discovered on social, no one knows it even existed, right? So how is AI helping us solve this problem? We're sitting on 15 years of library content. We're filming, every time Drink Champs film, they're submitting an episode that's 3 hours long. Okay, now someone has to go through, watch every single one of those episodes, find the most important moments, clip those moments out, give them to the social team, and then have them posted. So in the beginning, we were using an AI tool that would essentially allow you to drop it into the machine, and 10 minutes later would spit back to 12. It would look at the algorithms, what's happening in social, and spit back to 12, 10, 12, 14 clips that they thought were the most relevant for that moment. That was a game changer for us. Now, what the team is using is going one step beyond that. The AI tool that we have has full access to our entire library. It is always querying what's going on, what's trending, what's happening in social, and then looking across our entire library, hundreds of thousands of hours of content, and then making recommendations, spitting content out, and they can even post them to social pages. Right, that for us will be a game changer. If everyone else is waiting on 2 or 3 people to look at clips to figure out what's going to make it pop, we have a million robots doing that for us, right? And so we've seen our social numbers just skyrocketing based off of that. So that's one. 2, the R&D process for creating content is really expensive. So you're thinking about the way that Hollywood has always worked. Someone goes in and sells a show. Oftentimes, people will buy a pilot. You now got to go fully fund this entire pilot to see how the world's going to react to it. You may get 1 episode, you may get 6, you may get 10, then the show gets canceled. Okay, some of the most exciting things that I see now are people are creating trailers, leveraging AI around this content. And if you can get 3 million people talking, sharing about this idea, then it gives you a higher degree of confidence that, you know what, this is something that should probably go get made. So I'm excited about that, reducing our R&D costs. And then the last one, which is especially true for marginalized groups of people, is just AI reducing the cost of making blockbuster hits. And so the challenge I would argue that you have from a Black and brown perspective in the market is you don't get to see a lot of Black Marvels or Star Wars or these big $100 million, $200 million, $300 million productions. It's not because the stories aren't there. I believe they're hidden in our history, our blockbuster hits that have just never gotten to be told. It's not that the creativity isn't there. It's not that Black and brown people are not capable of coming up with whatever the next Marvel or Pixar is. It's that the cost of making that content has always been more expensive than people could, has always been more expensive, and Black and brown people had trouble unlocking the capital to fund the genius that they had. And so now when you look at AI, again, the ability to make entire movies, the ability to make 30-minute sitcoms, the ability to do all of this leveraging AI, I think is a potential game changer as far as an equalizing opportunity for Black and brown communities who don't get access to the capital, don't get access to the funds, and now they don't have to wait for somebody else to greenlight it or fund it themselves. They can get it done through AI. And it's happening. Last piece I'll say on this one, it's happening in different ways. Again, I told you Kenya Barris is one of our partners. He just finished completing, I believe, the first AI production for Netflix. It's some reinvention of like a Goonies type thing with young kids. And so from his perspective, he just shot what would be $100 million mini movie. I think it's 30 minutes. And they were able to do it for $30 million. So you're pulling 70% of the cost out of that thing, right? So I think that thing is going to be game-changing for Hollywood. I'm especially excited about what I think that thing could be for Black and brown people. And then the last piece is, so you talked about the threats, so I'll give you just a couple of my concerns. I know people talk about bias, misinformation. I definitely have all of those concerns, but I'll see if some of the other panelists probably can speak to those things better than I can speak to them. Where I think about it a lot is one of the hardest parts right now, if you're in the content business, is discovery. How do you break through, right? Back in the days when everybody was focused around one television and there was 10 channels, everyone is tuning into the same things. Today, the platforms that we watch on has us fragmented. And then you think about it, everybody in this room is a content creator and is probably posted on social media at least once today, right? And so what happens when you have this massive content explosion that we're already in, it's incredibly difficult to be discovered and found. I think there's tons of incredibly great content that is dying every day simply because it never got discovered. And now you take what I just gave you with AI, the ability to make it, the ability to make it faster, the ability to push it out. That problem is only going to be magnified by 1,000-fold, right? And so one of the biggest threats for content creators is just how will you get your work seen? How will you get your work identified? How will you get your work discovered? So that's one. And then the last one that does also, I'll just give you my solution to that is the discovery engine has to be baked into the content. So you have to find ways not just to tell stories, but to tell stories that can break through and be discoverable. We can talk about ways to do that, but I think that's one. Two, I think it's all about unique voice, like your unique thumbprint, your unique personal magic. If the machine is going to go put out the same thing kind of from everyone, how you really differentiate it is your own personal voice, your own personal point of view. So I think creators are going to have to get really good at that. And then the last thing that is always on my mind is what AI makes it really easy to do right now is copy. And so if you just think about it, if you had an app today that you thought was 80% close to what you wanted but wasn't the full 20%, you could just tell Claude, take this app and now build this 20%, and now you have it. So like we're entering into the era of peat and repeat. I had a friend of mine, I asked him to buy this app to help her make flowers. It was some sort of thing that would draw flowers for her, $6.99 a month. He was like, no, his daughter's 9. He said, no, go build it on Claude. She went and built the same app on Claude for free. So now, in a world where people can just easily create these apps that are stealing IP, imitating, again, now you're not just dealing with how do I break through or how do I get discovered, but how do I even get to protect and own the lane and the space that's really unique to my genius. So anyways, those are some of the thoughts that I have.
Excellent. Okay, guys, no going out and building exam apps, okay? Joe, what would be, you are a very accomplished lawyer in a huge firm, a great partner. What would be your response to each and everything that Detavio just said?
I know better than to respond to everything he said. But I think there's a lot of parallels in what he's saying, and it translates. And I think he talked about AI and using it as a tool, and that's what you want to do. You want to use it as a tool. I think, but first of all, I want to say there are CEOs out there. I was just with a CEO this week, and the first thing he says is, I use AI for everything, right? And so he tries not to be intrusive because he's at the top of a big organization. But before he comes to talk to you, he's probably already tried to figure it out on AI. So if that's what the CEO is doing, it puts a lot of pressure on everyone else in the organization to actually use AI. And there are also protocols in place to determine if employees are actually using AI. So it just shows you, okay, Joe Drayton, you've only been on for 2 hours, and everybody else is on for 40, in a given period of time. That's a problem, right? Because everybody should be focused on using AI. One of the things that Detavio said, and he's not the first person to say this, we hear this repeatedly, the single business with 1 million bots moving the business. And that's a little concerning from an IP perspective, right? Because if you only have one person, you build this big business, there's all kinds of things that this business is doing to be successful. And so, who is actually creating the intellectual property? If it's only one person, odds are they're not creating all the intellectual property, right? So it may be some special sauce in there that would otherwise be intellectual property, but it's clearly being developed and created by AI. And that's where you're going to run into a problem, because can you really protect that? And then you don't know, and Detavio touched on this, you don't know if you've stolen someone's intellectual property or you using intellectual property without authorization. So then these are the risks that can kind of open up. And then as AI pulled some code that is open source code, and that you've now given rights to what you've created, to open to the public. So there's all kinds of issues that have to be looked at. Taking the IP hat off for a moment, is the tech hat. I think with AI, people are concerned about data, and they're concerned about how do you protect data. And people are trying to say, what data am I prioritizing around protection, and what data am I not so concerned with prioritization or protection? And if you're not overly concerned about it, go at it with AI. If you're very concerned about data protection, then you have to have some protocols in place to figure out, okay, what's the best use of AI as it relates to this particular information, our crown jewels, whatever that is in any business. And then, we focus in on protecting that. So those are some of the things that, some of my reactions to Detavio. And this is, I'm not gonna say it's the Wild Wild West, but with AI, we're all in this journey together. So it's kind of like we're going down. It's like white river rafting. That's the term. We're all in our little rafts, and the current is hitting us, and we have to kind of figure it out. But the pressure is on, and so, there's a lot of things that in patent, the bureaus of patent, and obviously, AI cannot write patents, right? But AI can do a whole lot. And so I think as a tool, when we talk about marginalization, the biggest thing is, can you hire Joe Drayton? Can you hire Phil Hampton, right? Those are the questions that come to mind. Well, now, if you have your tech and you've written it and you've invested, AI can tighten it up for you. AI can look at prior art and figure out if someone invented something before. And you can look at the nuances to figure out how you can actually innovate over what's out there, what's already pre-existed. So when you talk about even in filing patents and thinking about, how do I write a claim? Well, you could write some claims and AI can tighten them up for you. So there's things that you can do to sort of protect IP in a low-cost environment. I'm not suggesting that everyone should do this, because you shouldn't, but you have the right to, right, to file your claims. You have the right to get things as tight as possible before review by an attorney, which also decreases costs. So even in our world, there are ways that attorneys can decrease costs, and there's ways that our clients or individuals who have ideas can actually save costs and reduce legal fees through the use of AI. What you don't want to do is go overboard with it. You don't want to start practicing law and shifting things to attorneys in that manner. You want to say, hey, here, I put a lot of work in, AI helped me make it better. The other thing that I wanted to touch on in litigation, AI has always been, so we're talking about generative AI. AI has always been in our world and in our space, but generative AI is a little different. And so people are really using it to prepare for like depositions. And so I'm an electrical engineer. And so you may have somebody who's not an electrical engineer, and they have a tech case now because everything is tech. And what they'll do is they'll use AI to teach them the tech, because all you have to do is have high aptitude time, right? And so they won't call Joe Drayton in anymore. They'll just do it themselves, and they'll get AI to write, not just write the deposition, but to be the deponent and to go through a deposition, a virtual deposition, a mock deposition, to prepare for the real deposition. And they'll feed AI themes of cases and things of that nature. And people have gotten great results using AI as a tool. I could go on and on about that, but the bottom line is it's a tool. It's extremely important, I think, to marginalized communities because it bridges a gap, right? And it gets, if they were on first base, now they could maybe get to second base, almost to third base, and that develops some cost savings.
Well, Joe, I'm interested in whether if you have a first-year law student out here, or even a second year, these the law students who graduate from Duke are just brilliant. You understand that, don't you?
I do.
So, why?
So you know.
James was a captain. James was Maryland.
Indeed, he was a Terp.
So, but why can't in 2 or 3 years one of these law students just hang their shingle and use generative AI to compete with any firm?
Well,
because you and I know it used to be in our era that the big firms would win cases because they would just drown small firms, drown sole practitioners, and just tons of documents, and tons of complications. Well, you can't do that now.
Do not do that. If anything, it may be to your disadvantage to do that because now AI can process the data and come up with new facts that you didn't even know existed that may be harmful to your case when you do a big data dump. So I think the days of big data dumps may be over in that regard, and folks may be trying to just give what is sufficient to give in a litigation as far as information is concerned, because it goes right into AI. And it's always been, so it's always been going into AI, actually. It's the generative AI piece. And I think the way that we're talking about using it, the bulk of the crunching is not necessarily generative in nature, right? So it's just an interesting thing. So I think, so to answer your question, the bottom line is you need experience to practice, right? And so without experience, you're not gonna have the sight lines. But
The sight line.
the sight lines. But I do believe that there will be solo practitioners because people are bright and they can study and everything is public. So the briefs that are out there, not all of it, some of it is under seal, right? Some of it is not accessible without fee. However, it is accessible. And so you can teach yourself, right? So you can learn the best brief writing, you can figure out style, you can figure out, it can help you do analysis. So if I can get 3 of the points right, and it's 5 that I really should be focused on, AI can help me get the other 2, right? So it could actually help you practice law very effectively if you put in the hard work, if you have to. If you don't have to, you should probably get training, you should probably get perspective. But we know that there are a lot of law students out there, and there's a lot of law schools out there. And that gap is going to be bridged. And also, when you talk about plaintiffs versus defendant, and you talk about huge class actions, you talk about a plaintiff's bar, they're using AI as well. And it's allowing them to bring more class actions, to do more analysis, to actually be more attentive even to their clients, because they can use AI to help them with come up with one-page summaries so they can make calls to different clients. So lawyers are actually more effective using AI even in that context as well. So I do think you'll see some star lawyers come, right out of law school effectively using AI. And some will be misusing AI and some will be sanctioned, but it's a numbers game, right, as it relates to that.
I'm gonna come back around to you. Judge, now you've heard all this and you've been at the PTO and that's sort of the front end of the management of intellectual property rights. So, and then and Judge James Smith, of course, worked there also and made certain changes. So can you tell us what certain changes he made to manage this universe and how maybe some of those changes maybe help marginalized groups?
Sure, I'd be happy to do that. Maybe to start out, just so everybody is at least on the same page as to the U.S. Patent and Trademark Office. It is well, as the name suggests, it issues both patents and trademarks. They have about 13,000 employees, largely at the Alexandria headquarters, although there are regional offices around the country, and there are a number of still full-time teleworkers, despite the executive order trying to abolish telework. But we could talk about telework on another time. So what they do is, the patents organization takes in patent applications from inventors, and there are about 8,000 patent examiners at the office in all different technologies, and their job is to examine the application. If it meets the standards, to issue a patent. There are a couple of ways once a patent is issued to maybe bring it back to the office, and that's sort of where the Patent Trial and Appeal Board has a role in that. It also has a role while an inventor is trying to get a patent. If the examiner rejects it, then there's a route to appeal internally within the agency to the Patent Trial and Appeal Board. There's kind of a parallel structure on the trademark side. You have trademark examining attorneys who examine and will issue trademarks, and if there are rejections, there's a Trademark Trial and Appeal Board that will look at those internal appeals. But then once the patents are issued, and this is sort of where Judge Smith and his legacy comes in. This is back in 2011. The America Invents Act was passed and signed by President Obama. And a year later, and Professor Rye alluded to this, the act went into effect with brand new trials that had never been seen anywhere before. We're going to go live in 1 year after the passage. And now, Chief Judge Smith came to the board before the passage of the AIA, back when it was known as the Board of Patent Appeals and Interferences, and he was the last chief judge of that board and the first chief judge of the newly created, or at least seems to me new, it's new in my memory, back in 2012, the new Patent Trial and Appeal Board. And it was going to involve a lot of work. There was a lot of work in the appeals internally, and that had been going up, but the size of the board had not kept pace to match it, so those were getting longer and longer before patent applicants could get their decisions. And then you had these brand new trials, and nobody knew how many are going to be filed. What are these things exactly going to be like? Oh, by the way, you need an IT system to take in the pleadings, to take in the evidence, to issue the decisions. That had not been created, and if anybody has experience with government IT, those wheels tend to turn very, very slowly. So getting a computer system up in a year, plus issuing regulations, which also traditionally take about 1.5 to 2 years to issue, and you only have 1 year to do it, plus you've got to hire judges. I would say that Chief Judge Smith was the right person at the right time to do all that, because, as Professor Rye mentioned, he had boundless energy. He had the intelligence, the integrity, and the vision to bring all that together. So he went about hiring the most explosive hiring spree the board has ever seen. We started out the beginning of his tenure around 90 or so judges. By the time we were done, it was up around 275, so it was tremendous growth. He also helped open the regional offices. In fact, Judge Smith made sure, in order to attract this talent, he realized you can't get it all in Washington, D.C., or get everybody who would want to be part of that to move to the D.C. area. And the office was establishing regional offices in Detroit, Denver, which unfortunately now has been closed, in Dallas and San Jose. Chief Judge Smith made sure there were judges hired into those offices before those offices formally opened. So he was ahead of the game on that. And he made sure that he looked at all of the public comments that came in on the procedures. What should those look like? And help shape those. They held up remarkably well. Here we are in 2026, and there have been tweaks along the way, but the overall structure and the way the proceedings went, at least until this current year, were pretty much the way that they were when they were rolled out, back in 2012. And so again, I think he really had the drive. He also had a drive for excellence, and he did not tolerate slop, and was one for precision of language, precision of thought, was very demanding. Again, it was sort of, as Professor Rice said, he wanted to earn the respect, to earn the place, and also earn the respect of the reviewing court, the Court of Appeals for the Federal Circuit, because there was a lot of doubt, at least at the beginning. People doubted, well, could the board really do these trials? They'd never done anything exactly like it. There was a legacy proceeding called interferences, which was somewhat arcane, but inter parties proceeding, but it was very small volume. And people sort of doubted, could the board do it? Congress did require the board meet timelines that are written into the statute. There are times that have to be met, and people were thinking, they're gonna blow those deadlines. Well, the people who thought that didn't know James. It was not gonna happen. And I can attest, I was thinking about, again, Professor Rye was mentioning hard work. James would talk about having 3 shifts, and he would, and between his second and third shift, he would go to the gym across the street, which was closing, and he would tell stories with great annoyance how the attendants at the gym didn't want to let him in because it was almost closing time, and there he was, because he was ready to do his workout before the third shift. So again, it was a lot of energy, the multitasking, even though the patent office is close to National Airport. I remember many meetings where James had a flight and we would tell him, hey, you need to leave now to get on. I was like, no, I got a few more minutes. And by the time we were done, I was like, well, let me see if I can rebook that flight. And so he was just, as I say, one of the smartest, most driven, and driven to excellence individuals I've ever encountered. And I was, privileged to have him for a mentor to sort of show the way of how to do things. So he, I think, would have found this era of artificial intelligence very interesting, and I think he would have, both looked at the opportunity, but I think he also would have been annoyed with a lot of the AI slop and hallucinations. I could just see that driving him crazy, and those are, some issues that the office, I guess, is starting to see, and I guess it's, sort of been talked a lot in the legal world, the hallucinated citations, are arguments that seem to really not make any sense, and you wonder, did anybody, read this? Fortunately, at the Patent Trial and Appeal Board, this didn't happen very often, but it did set up some questions about, well, what do we do about this? And I know there were differing thoughts. Some people thought, you should make them certify that whether there's been a use of AI. And I think, at least, in my view, maybe calmer heads prevailed and went back to the duties of the lawyer. When you submit a filing, you have Rule 11, and the lawyer needs to, double check whether it's hallucinating AI or a hallucinating paralegal or associate. Is this a real citation? Is this the right citation? Is the argument well structured? Those sorts of things are still the burden of the lawyer. And at least that's where the office landed, rather than trying to ask, well, did you use AI? Because who knows? You probably did, honestly. If you're thinking about it these days, it would be hard to say you didn't, or you didn't encounter it. But the office has been a little slow or cautious, which may be a good thing, just because there are a lot of sensitive, inventions. The inventions until 18 months after they're filed are secret, and they're required to be held secret. So there are concerns about privacy of the information. You don't want it to leak out. To the extent that AI is being used, it's sort of a homegrown system that the office is working on building. And for a while, it's funny to see the policy shifts. It's when generative AI first came out, the chief information officer sent a memo and said, you may not use AI, like, period. That was, no, just, absolutely not. That has, loosened, and over time is becoming more encouraged. The office had an internal, they called it Scout. I guess it's sort of the ChatGPT Claude of the agency, but again, trying to keep the information within the USPTO. And they're slowly letting more and more people experiment and test it. So it's sort of small, but growing as far as the use at the office. And they're using it to do things, for example, to route a patent application to an examiner, because that's a really tricky thing, getting the right application to the right examiner who understands that technology. And sometimes things are a little blurred. I mean, these days, when I'm looking at what you might think of, or they're categorized as an automotive invention, it's really Wi-Fi, or it's some Bluetooth standard or something. So how do you get that to an examiner who is in that group, who knows the technology, and they're experimenting with AI to do the routing, experimenting with AI to do patent searching, because as time goes on, the volume of references, what they call prior art documents, knowledge, is growing. And how do you search that? How, in a reasonable time? So they're trying different uses of it. I think it's appropriately cautious for its role. I know that the bar, I think, and folks I've talked to at the bar have embraced it quite a bit more at the moment than the office is, but it'll be catching up.
Thank you, Judge. For interest of time, I'm going to go to Fume, and I would set her up for a question, but she's been jumping at the bit. So I'm not going to set her.
Yeah.
So I'm going to be quick, and I have my timer on, so I keep track of myself. I'm going to start with an AI disclosure, because I think it's been a really interesting learning curve for me using AI. I have to admit, I use AI for just about everything. I use Notebook LM for certain things. I do a lot of archival research. Notebook LM is phenomenal if you have hundreds of documents and you're trying to find something. I could either spend a few hours looking through the documents, or I could put it in Notebook, which will highlight where it is in the document for me. So for my archival research and some of my class stuff, I use Notebook LM. I also use Perplexity for my general prompts. That's what I started with. I used to just prompt. And I also use Claude Cowork. And in setting up my Claude Cowork space, I would say it's been a little challenging, but I do live with a husband who's a programmer. So it made it a lot easier, because I could just ask him, I don't understand what I'm doing, help me, and he helped me. So for my remarks today were prepared with the assistance of Claude Cowork, Anthropic's Claude Cowork. And what I did is the training material I gave it was everything I've ever written and every presentation I've done in the last 10 years, as well as specific articles that I thought were relevant to what I wanted to talk about today. We put together remarks together. And as I read the remarks, I said, okay, I edited them and changed them. And then I said, oh, there's this other thing I want to input that I read that I forgot about. And I would just dump it in my Claude folder, and Claude would incorporate it, and then I would edit it. And so it was an iterative editing process. And I can tell you that I think AI is the way of the future. And we will all be using AI. As I tell my students, it will be the lawyers that can use AI that will replace the lawyers that can't. That said, I think Detavio, we're going to need fewer people. So that's a debate. I think that's something we're going to have to see over time. My guess is that means fewer lawyers, because you don't need, in the kind of due diligence I did when I was a young associate doing transactional work, you would sit in a room, it was still paper in those days, and you would be there for like 12 hours at a time. One week when I was doing M&A due diligence, I did 3 or 4 all-nighters in 1 week. So that, you don't need people to do that anymore. Now, you might need some high-level people, but you need a lot fewer human hours for that kind of work today. And that's the reality when I talk to my students about AI, all of whom use AI and are sending me APIs and things that I should use for my own Claude Cowork setup. I think we're all engaged in this conversation about what does that mean for the future. So that tells you where my remarks came from, and you'll have to tell me whether I was successful or not in my collaboration with Claude in my remarks. So I want to zoom out for a second. First of all, I want to thank Professor Jones, Giovanni Martinez, Brent Clinkscale, who organized this, and the Duke Center on Law, Race and Policy for organizing this really important event. And I think that this is a conversation, I didn't know Judge James Smith, but I think this is a conversation that he would have found really appreciated deeply. In addition to his legal work, as we've heard about, spanning public service, academia, and private practice, he was committed to advancing diversity in IP, and he was also a musician. I'm an opera singer, so I love anyone who's a musician. He was an accomplished violist, and I understand his concerts. He would have small concerts, and he was it was the kind of thing I would have loved to have attended. So I'm gonna zoom out for a minute. I want to talk about AI from a higher level perspective, because AI is arriving in a world in which we already have marginalization. We already have a starting point for AI in which we're not starting at the same point with AI. And I think that has big implications, especially since I write about music, and the plight of music in the digital era, unlike media. I mean, there's been some sad things in media, but I think the plight for many musical artists is really still sad in many respects. And a lot of it goes back to what Detavio said about distribution. We have distribution in music that was set up in the 1920s, and we still have the contracts that were established in the 1920s are still the ones that govern the music industry. And musical artists, for the most part, don't have control of distribution. And it turns out that's what's really key. We don't have physical distribution anymore. So we have a lot of path dependence in terms of what music distribution looks like in ways that have been a continuing problem for musicians. So every time we have new technologies that roll out, musicians say we're not getting paid, and they probably aren't getting paid. I think, as my data suggests, I think musical artists get 12% of the money generated by music. That's really not a lot. And that number's gone up a little bit, but it's only because people are touring madly and the money from touring has gone up. And so I'm gonna start out by zooming out. I want to talk about the pre-AI landscape, wealth, assets, and marginalization. And I'm actually gonna start out with a surprising quote by Larry Fink. You may know, in 2020, every year Larry Fink does an annual letter to CEOs. His 2026 letter, I think I saw on Monday this week. He's the CEO of BlackRock, which is the largest asset manager in the world. They have $14 trillion in assets under management. So today, this is not typically the profile of someone we would think about as being concerned about inequality. But he actually has had a longstanding concern about this. And this is a quote he said in his letter from earlier this week. The vast majority of wealth has flowed to people who owned assets, not to people who earned most of their money by working. Since 1989, a dollar in the US stock market has grown more than 15 times the value of a dollar tied to median wages. Now AI threatens to repeat that pattern at an even larger scale, concentrating wealth among the companies and investors positioned to capture it. So I want to talk about the starting point and what that means for us when we think about how AI affects our society more broadly. Larry Fink goes on to say, this is where much of today's economic anxiety comes from. A deeper feeling that capitalism is working, just not for enough people. And I don't think AI is going to make that better. And the question is, how do we think about ways to sort of minimize the deleterious effect of AI for people that are already marginalized? So, and a lot of my work talks about this. So he was writing about the broader economy, but this applies in the creative industries. And I'm specifically going to talk about music because I think it is a big issue in music. Because artist poverty is a thing. Many artists cannot earn enough money from their art to actually support themselves on a day-to-day basis. And there's sort of a linguistic footnote because the term gig, we talk about the gig economy, but that comes from music. We talk about the precarity of the gig economy. And that just reflects how musicians, a lot of performing musicians and recording artists have always lived. They've always made most of their income from gigs. And that's not always reliable, as we saw during COVID. During COVID, the gigs went away because we could no longer have live events. So that ended up being devastating for a lot of, not the most successful multi-billionaire, billionaire musicians. They'll do well regardless. But for everyday musicians who are just trying to earn a living, it can be really devastating. And I think the legal scholar Jessica Littman has described the underlying structural problem with her characteristic clarity. She says the copyright system in truth has never been very good at either giving authors their choice of myriad channels for distributing their works to the public or enabling them to earn meaningful amounts of money from doing so. The majority of creators regularly face the choice of living perilously close to the poverty line or working a day job to support their families. So this is the baseline. Before AI, this was a baseline for a lot of creative artists, certainly for a lot of musicians. Before we had generative tools, before we had large language models. So we know that for many artists, things weren't working as well as they should have been. And for people from marginalized communities, which is many artists, it's even more of a problem. And in a book, I'm writing a book called Curating Black Culture, Music, Money, and Marginalization. And I talk about double marginalization in my book. So what I see is African-American musicians, historically and in the contemporary era, may face the general precarity that too many artists face, compounded by the particular vulnerabilities that come because African-American musicians have long operated at the margins of industries that have historically excluded them. Now, the patterns of exclusion have changed. We don't have Pat Boone sort of covering Little Richard recordings, but we do have questions. If you look at Lil Nas X and Beyonce about what kind of music they should actually be allowed to perform and whether it's really country music or not, that's a longstanding issue that African-American musicians have had to deal with since the inception of the recording industry, because genres, the recording industry started with this idea about what kind of music people of different races should perform. Their idea was authentic Black music was blues, and authentic white music was what they called hillbilly music. And that meant that if you were a Black hillbilly band, it was very hard to get recorded. It's not that none of them got recorded, but there were many, many African-American hillbilly bands at the time the recording era got started. And I think the Carolina Chocolate Drops have really sort of gone back and tried to reclaim some of that history. But when we think about marginalization, it's about economic marginalization. It's about your ability to perform the kind of music that comes from the heart. That remains race-based to a significant degree in the contemporary music industry, because certain genres, rock, pop, and country, are seen as being white genres still. And you can see that in Grammy categories. And this is an ongoing discussion we have every year when the Grammy Awards categories come out about, wow, there's sort of a racial thing going on in the Grammy Awards categories. And this is 2026. And I'm sure it will, 2027, I expect that same discussion to happen. So I want to jumpstart. So I talked about how musicians earn just 12% of the music revenue, or artists earn just 12% of the music revenue. So this is our starting point. So these patterns are historical, and I could talk for a long time about a lot of different historical cases. I'll just briefly talk about one, R&B singers of the 1960s. These are artists whose recordings still circulate, they're still streamed. They often reached retirement age in conditions of precarity. Why? Because they weren't getting paid their royalties. And many of them went to people called royalty recovery experts. And these are people like Stephen Levere in the Robert Johnson estate. He said, okay, I'll go collect royalties for you. And he charged 50% of what he collected. In these royalty recovery cases, there are hundreds of these cases. And people are trying to get out of these contracts, and the courts are not very sympathetic to those. I'm going to write about those later, so I probably have more to say about those later. So key issues: unequal power, business knowledge, and accounting expertise. Because where artists get shortchanged from a royalty perspective is in the accounting. The accounting, there's often misaccounting. One expert that testified in a California legislative hearing said that finding an accounting statement where the error is in favor of the artist is like a Bigfoot sighting. So anytime someone does an accounting, the error is always in favor of the recording industry, and it's systematic. And the problem is it's so difficult and so expensive to do an accounting, only the most successful of artists can do them anyway. For many artists, we're only talking about $10,000 or $20,000 a year. For many people, that would make a huge difference in how their life is lived and how well they can live. So I think it's something we really need to focus on, and that's what I'm focusing on in my research. I want to say a few things about AI. So AI comes in this environment where we already have marginalization for many artists, double marginalization for many artists from historically marginalized communities, including African-American artists. And the thing is, I want to highlight, African-American music is the core of popular music. It's not as if this is sort of a remote sort of esoteric music. Popular music is built on African-American music. The music scholar Susan McClary talks about how successive series of African-American music musical genres have been the core of popular music today. And she talks about how if an alien went back, at this point it would be 150 years, and went back to how music sounded, they would be really perplexed by the sound of music today versus what music sounded like in the age of sort of around the Civil War era. Music sounded very different. Our ears have changed, and it's all because of African-American influenced music. So AI, what are my three specific concerns about AI? AI has bias embedded in training data and categorical assumptions. And that is something that is hard to unpack. In 2015, Google's photo app, you probably heard this story, automatically tagged uploaded photos using AI algorithms. It's mistakenly labeled Black people as gorillas. So a problem. So if you uploaded a photo with a Black person, it would tag it as a gorilla. So Google solved the problem by blocking its image recognition algorithm from identifying gorillas, chimpanzees, and monkeys altogether. These types of biases continue. A 2023 Washington Post investigation of AI image generators like Stable Diffusion and DALL-E found that the tools reliably amplify our worst stereotypes. When prompted for attractive people, the AI generated images that were young and light-skinned. When prompted for a productive person, results were uniformly male, majority white, and dressed in suits. When prompted for a person at social services, the AI generated only non-white, primarily darker-skinned people, despite the fact that in 2020, 63% of food stamp recipients were white. And in training data captioned Latina, 20% of the captions or URLs included a pornographic term. So these kinds of assumptions that exist in the real world are being translated and intensified in the AI era. The impact of these stereotypes will fall most heavily on the same communities harmed during earlier eras. Second, the narrowness of technology companies building these systems. When I practice law, I practice in Silicon Valley, Boston, New York, with technology startup companies. So major AI developers are amongst the least demographically diverse institutions in our economy. The teams building these systems don't reflect the diversity of our population. And from both a domestic and global perspective, this means that there may not be adequate critical examination when things come up and when images are generated because the people are too narrow in terms of where they come from. And that's something that could be fixed. It has not yet been fixed. Third and last, actually I have four. Contextual misrecognition. I'll say quickly, AI making systematically wrong assumptions about context. And this came out most recently. Ted Joya last month had a posting on his Substack. He's a Jazz Scholar Panist writer about AI-generated tracks that are using the names of African-American jazz performers. Last but not least, the environmental cost of AI fell disproportionately and on the same communities already carrying out the greatest burden of inequality. I'll stop there and let's have a discussion.
So good afternoon, everyone. And clearly this discussion is to be continued. It is rich and enlightening. I'm Giovanni Martinez, Senior Lecturer and Fellow and Executive Director for the Center on Law, Race, and Policy. On behalf of Professor Jones and me, thank you so very much for such a wonderful, enriching, timely conversation, honoring our friend, Judge James Donald Smith. I still remember meeting Judge Smith, how generous he was with his time and talents, his kindness, and his willingness to share insights and knowledge with others. And I'll be very brief in my remarks, but just acknowledging that even, wanting to, as Judge Boalick mentioned, right, even go right up to the time, we just can't reschedule this flight today. Right, but you see, the Center on Law, Race, and Policy advances racial equity by empowering the next generation of leaders, particularly our law students in the room, in the legal profession. Our educational programs, cutting-edge research, and community partnerships foster understanding of the interplay between race, law, policy, and people. These events and events such as the one today furthers our missions, and we firmly believe that such a mission is in line with Judge Smith's views because we know that personally. I still remember when we met with him and his readiness to support the efforts of our censor. So without being long-winded, thank you very much for being with us today, for the panelists, for the roundtable that's going to take place afterwards. Just a few more notes, and that is, we also want to thank our, Becky Chapman, Tatiana Farrow, and everyone behind the scenes to make today possible, to the students. For our panelists present here today, the roundtable will take place upstairs in room 4172, starting at 2. And last, in line even with Judge Smith and his efforts, if anyone wishes to support the efforts of CLRP, the Center on Law, Race, and Policy, please visit our donate tab at our website at racelaw.duke.edu. With that, thank you for this wonderful, enriching conversation. Please be on the lookout for more in the continued conversation that has started today. With that, thank you for joining us and have a wonderful rest of your day.